Hello guys, and welcome to another episode of my lecture. Today we'll be talking about the case of TESCO Supermarket Limited versus NATTRESS. So let's go to the fact of the case. The fact is that T offered a discount on powder advertised on posters in stores. After low price products finish, they restocked with regular priced products. The manager failed to take down the poster and the customer was charged at a high price. TESCO was charged under the Trade Description Act of 1468 for falsely advertising the price of powder, and they sought to rely on defense of act of omission of another, and that the manager's conduct could not attach liability to the company. Now, the trial court held that the manager wasn't another person, therefore, the act of the manager was the act of the company. The House of Lords, on appeal, held that the manager was another person within Section 24 sub 1A, and that the defendant had taken all reasonable precautions to ensure avoidance of offences. The manager wasn't part of the directing mind, and his conduct wasn't attributable to the company, for the corporation had done all it could to enforce the rules of advertising. Lord Reed stated that for liability to attach, it must be the case that the person who acts isn't acting for the company, he is acting as the company. His mind directing the company is the company's mind. Do you understand what this means? For there to be liability, I love this. For there to be liability, his act shouldn't be the act for the company. It should be the act as the company. It should be acted as the company, not acting for the company. Normally, the board of directors, the managing director, and other superior officers speak and act as the company. However, their subordinates don't. They carry out orders from above, and there is no difference that they are giving some measures of direction. But the board of directors may delegate some part of their function of management, giving full discretion to their delegate to act independently of instructions from them. It is in such situation the delegate is put in such a position that he can act as the company. Lord Reed noted that it is possible for a board of directors to delegate an embodiment of the company within the sphere of delegation. When they say within the sphere, it means that the board of directors must have the power to delegate in the articles. First of all, the board of directors must have that power vested in them. Then secondly, they must have the power to as well delegate, because you cannot delegate what has not been given authority to delegate. Do you understand? If the articles tells the board of directors not to delegate, the board of directors cannot delegate. And secondly, the board of directors cannot delegate a power that was not vested in them in the first place. So reading from what Lord Reed has said, he said it is possible for a board of directors to delegate an embodiment of the company within the sphere of delegation. But in this case, the board of directors never delegated any part of their business, although they set up a chain of command through regional and district supervisors, but they remained in control. The shop manager had to obey their general directors and also had to take orders from their supervisors. Therefore, the act and omission of shop managers weren't the act of the company itself. This basically just reinforces what we've been saying. But in this case, there was a difference. In other cases, starting from Leonard's case, there was no supervisor. Meridian's case, there was no supervisor. The Lady Gwendolyn, there was no supervisor. But in this case, there was the board of directors. According to Lord Reed, he said that the board of directors never delegated their power. They only set up a chain of command. And this chain of command still had to submit to superior and superior until it got to board of directors. The board of directors had already complied with the provision of Section 24 sub 1. Therefore, they've taken reasonable precautions, because the board of directors had already issued that they should bring down such notices about the discount. But this particular manager failed to bring down the notice, and then the company was sued to court, and they are saying that the act of the manager is the act of the company. The court held that no, the act of the manager here is not the act of the company, because he has supervisors, and his supervisors has ordered him to do A, he did B, therefore it is the manager. He wasn't acting as the company in that case because he was under certain supervision. He was only acting for the company. Do you understand? And for the act of the person to be the act of the company, he must be acting as the company. Do you understand? And you acting as the company means that there is no supervision over you. It's just like the board of directors. Any resolution that comes from the board of directors would definitely be an act as the company, because the board does not have any other supervision. Do you understand what I'm saying? Now we go to the last case, which is the case of Ehrlich versus Lifa.